Good afternoon, Ms. Duran.
Good afternoon.
And you've been in the trial ever since opening statements, correct?
Yes.
You're aware you're being charged with intentional shooting?
Yes. Yes. My child is being charged. I'm held liable for my child.
You also understand that one of the elements that the plaintiff has to prove today is that Jesse knew what would most likely occur if Jesse shot him. You understand that, right?
Yes.
I'm going to ask you a couple of questions now. You taught your daughter the difference between right and wrong, right?
Yes. When Jessie played video games, I played with her the first couple times. And I always made sure to remind her that the images she saw weren't real and that guns were dangerous.
Those video games, I want to get into that. You taught your child that everything that you see in the game is pretend, right?
Yes.
Told your child guns were dangerous.
Yes, of course.
You asked your child if she understood what you were saying, and your child nodded in acknowledgement, right?
Yes, Jessie.
I want to talk to you now about how you felt when it comes to the concerns of Jesse. Your Honor, let the record reflect on the report of the opposing counsel. The proposed exhibit plaintiffs 3. Let the record reflect on the report of the witness with the same. Mr. Rand, this is a notification of student discipline, right?
Yes.
You saw this on April 6, 2010?
Yes.
This was while Jesse was still in school, right?
Yes.
That's your signature at the bottom of this notice, right?
Yes, of course.
This means that you understood what this was saying, right?
Yes.
Your Honor, at this time, plaintiff moves P3 into evidence.
Objection, hearsay.
Explain.
This is an out-of-court statement being used for the truth of the matter.
Your Honor, may I respond?
Yeah.
Pursuant to Rule 801D2B, the party appointed exception, if the party appointed believes an out-of-court statement to be true and adopts it to be true, then it becomes an exception to hearsay by the party appointed exception. I asked this witness, has she reviewed this document? She signed the document, therefore she adopts it to be true, what the contents are in thereof.
Mr. Francis.
It has not been written by Hayden. It does not fall under 801D2.
Again, Your Honor, the rule states that it does not have to be made by the declarant. It can be someone else who wrote this notification of student discipline, as long as she had a chance to review it, and as long as she believes that the statements in this document is true. And I've laid that foundation.
No rule.
Motion to put this into the record.
Granted.
I want to point a few things out, Mr. Rand, and tell me if I'm misquoting this. At one point, Jesse's 5th grade class was playing dodgeball against another class. At one point, the teacher heard Jesse scream, "Hey!" and saw Jesse run across the gymnasium to the other side, on the other team's side. Jesse grabbed another student's arm and yelled, "I hit you. You're dead. You need to fall down and die." The other student tried to pull away, at which point Jesse began to violently kicking and punching the other student. I read that correctly, right, Ms. Duran?
Yes.
Let the record reflect on punching this witness and retrieving evidence. Permission to publish to the jury.
Yes.
This happened in April 2010 before the shooting, right, Ms. Duran?
Yes.
I want to talk to you about a picture you saw your daughter draw June of that year. Your Honor, let the record reflect on the question of opposing counsel with plaintiff's proposed exhibit number 4.
It shall so reflect.
Let the record reflect on approaching the witness with the same. Ms. Park, you recognize that to be a picture that your daughter drew and you found June of 2010, right?
Yes,
That appears to be a fair and accurate copy.
yes,
You recognize the drawing to be the handwriting of your daughter, right?
yes, this is Jesse Strong.
Your Honor, at this time, plaintiff moves plaintiff's forward in evidence.
Objection, Your Honor. This evidence is more prejudicial than probative.
Response?
Your Honor, if I believe the opposing counsel is referring to Rule 403, this evidence has to be substantially more prejudicial than probative, and this evidence is not.
Response?
It shows Jesse shooting things which will duly bias the jury.
Your Honor, may I respond to that?
Yes.
This evidence is being used to prove knowledge. In today's case, we have to establish an element, and that element is that Jesse knew what would likely occur if she shot a gun. This picture is going to show knowledge of Jesse Durant, and not to prejudice the jury in the pictures that are in it. Not to inflame the jury, just to show what Jesse knew about guns.
I'm going to sustain the objection. If you've already discussed the use of violent video games, that should be enough.
Yes, Your Honor. Commissioner reports the witness retrieved. Mr. Rand, I also want to talk to you about an email you sent one of your friends in July 1st, 2010, before the shooting. Let the record reflect the report from the opposing counsel with the email. Mr. Rand, you recognize this to be the email that you sent to one of your friends concerning Jesse, isn't that right?
Yes, this is the email I sent one of my friends as a concerned parent.
This appeared to be a fair and accurate copy.
Yes,
The statements in this email were all from you.
yes,
Your Honor, plaintiff moves Exhibit 5 in evidence.
No objections, Your Honor.
Now, tell me if I'm recording this wrong. I'm a little worried about Jesse. Jesse's been interested in guns for a while, and I want to skip down to in the middle of it. I even caught Jesse and Sydney playing a 2-player version of the game where instead of shooting the bad guys, they were taking turns shooting each other. And on the very end, you heard Jesse pointing sticks at kids and saying, "Bang, you're dead." I read that correctly, right?
yes, I was simply concerned about Jesse's behavior in this email.
Commissioner reports the witness and published to the jury.
Great.
Lastly, Ms. Moran, I want to talk to you about August 17th, the day before the shooting. Now, Danny Brooks, the Park's babysitter, came to you and told you that your daughter knew that Ms. Park owned a gun, right?
Yes, Danny always confronted me. He always seemed a bit too concerned about Jesse.
Your Honor, strike the latter portion of the witness's answer as non-responsive.
Objection, Your Honor. The
Okay.
witness will need to explain himself more.
What was the question?
On August 17th, Danny Brooks, the babysitter, told you that Jesse knew that Ms. Park owned a gun. This witness then, latter portion of the statement,
What was the first part of the statement?
Yes, Danny always seemed a bit too concerned about Jesse.
Overruled.
so the latter portion's stricken from the record, Your Honor.
No, it's in.
Yes, Your Honor. Now, after this, you told your daughter that guns were dangerous, right?
Yes, I always made sure to remind Jesse.
That real guns and fake guns in the video games, but real guns can hurt people, right?
Yes,
You told Jesse that real guns could even kill people. Isn't that right?
yes.
Your Honor, I have nothing further.
Thank you. Any redirect?
No redirect, Your Honor. I asked that my